important legal issues in Georgia, including auto accidents, personal injury cases, and criminal defense law. Here is your host, Attorney Jason Carnell.
Hey folks, Attorney Jason Carnell here again. Thank you for tuning in to another one of my videos. Today what I'd like to cover is a criminal matter, specifically the conditional discharge. Okay, I've done a video on this before. The video itself is not outdated or anything. The information is really still the same, but with the way Google algorithms work, they do tend to prioritize newer content over the older stuff, and it's been 6 years since I recorded that last video, so I think now is time for an update. To the best of my knowledge, there are two conditional discharge statutes. One is related to drugs, and the other is related to minor in possession of alcohol. So what is conditional discharge? Well, conditional discharge is a program, I guess you could say, that allows you to enter a plea under the conditional discharge statute. And once you successfully complete your probation, your conviction is reopened and the charges against you are discharged. Your conviction is discharged. Okay, what does the word discharge mean? Well, sort of dismissed, deleted. I think those are probably the best two words to cover it. So the process, again, you actually do have to enter the plea. So let me give you some examples. Misdemeanor marijuana possession is probably the most common conditional discharge in the state of Georgia. There are countless people, hundreds of thousands a year probably. If you get caught with less than an ounce of marijuana, you could be offered a plea under the conditional discharge statute. So you're actually pleading guilty. You stand in front of the judge, you waive all your rights, your right to a trial, your right to see, hear, and confront the witnesses against you, and you're entering a plea of guilt, and you're being sentenced to a period of probation. It's usually 12 months. While you're on probation, you are to complete certain conditions. That's where the conditional part of the conditional discharge comes in. Usually, in that case, we're talking about a drug and alcohol evaluation, a fine, community service, random screens. When you are done with your period of probation, the case is reopened and it is discharged. You are acquitted. You are not convicted. Since 2013, the record restriction statute was updated that if your case is dismissed pursuant to a conditional discharge, then you automatically receive a restriction of your GCIC criminal history. Okay, and that's record restriction. It's automatic, assuming you successfully complete your conditional discharge. Now, like I said, there are basically two conditional discharge statutes. One is for drugs, okay, and it covers a wide variety of drug offenses. And then the other one is for minor in possession of alcohol. The whole idea of these is to get people the treatment that they need to try and treat drug use and possession and of course alcohol, in the case of minor in possession of alcohol, as a public health issue, even though it's still a criminal issue, to get people treatment and to give them a second chance. So if you've been charged with either one of these and you have no prior criminal history, you might be eligible for a plea under conditional discharge. But whether or not that is the best option for you is really something that you would probably need an attorney's advice for. So if you've been charged with these, my advice would be to consult with an attorney. Consultations with me are always free. You can call my office at 770-322-4990, or you can visit my website at www.carnellfirm.com. Thank you for tuning in, and I'll see you next time.
Thank you for tuning in for another episode. If you found this video helpful, please like and share it. If you have questions, remember, consultations are always free. Just call Attorney Jason Carnell at 770-322-4990, or you can visit our website at www.carnellfirm.com.